This week, it was reported that the Biden administration is fighting to keep student debt an inescapable nightmare. Discharging student debt in bankruptcy is almost impossible, reports above the law. The Biden administration is fighting to keep it that way. This article is written by Joe Patrice on February 2nd, and as opposed to just reading the article for you, I want to talk about the underlying case and see what's going on here. It's not that terribly long of a case, and we can then look at what happened afterwards, because there have been consequences to the Biden administration's Department of Education pursuing an appeal of this decision. This is in the case of Ryan K. Wolfson's bankruptcy, and because of when it was filed, it looks like it's a 2019 case. Betsy DeVos was the Department of Education secretary. In this adversary proceeding, now, so bankruptcies are not typically adversary proceedings. You declare bankruptcy, and then the bankruptcy trustee works with you to make sure everything is in line, and then the court handles any disputes. When you have a debt that is disputed, like your student loans, someone has to oppose that discharge of that debt, the elimination of that debt. And that would be an adversary proceeding, and the adversary here is the Department of Education. It was Betsy DeVos, but now, because we've had a switch in presidential administrations, it's now the Biden administration Secretary of Education, who I forget what that is. I'll put it up on the screen. Debtor Ryan K. Wolfson seeks a determination that his student loan debt, comprising numerous draws under two outstanding loans, now totaling about $95,000, is dischargeable under the bankruptcy code. Student loan debt is only dischargeable if repayment of the debt would impose an undue hardship on the debtor. The way this normally works, when you file a Chapter 7 liquidation bankruptcy, or even a Chapter 13 reorganization bankruptcy, once you complete the requirements under the law for a discharge of the debt under bankruptcy, the unsecured debts are just simply eliminated. In a Chapter 13 reorganization bankruptcy, you may pay off part of the loan, whatever you can afford, over the course of 3 or 5 years. There's various tests for this. But then the unsecured debts are eliminated. Secured debts would have the property sold unless it's covered by a bankruptcy exception, like a homestead exception that allows you to keep your home under certain circumstances. Normally, student loan debts are not dischargeable in bankruptcy. Willful torts are not dischargeable in bankruptcy. But your credit cards are not generally secured by property. Those are just simply wiped out. Your car, if you can't pay for your car, the car is a secured debt. The loan is usually secured by the car. So if you wanted to discharge that debt, then you need to sell the car. The trustee will help you sell the car, or will sell the car for you. And then that money pays off the loan, and what's left is discharged. So student loans are not normally discharged, and this is a rare case where student loans do get discharged, and they only get discharged if you can show an undue hardship on the debtor. The test for undue hardship in the Third Circuit Court of Appeals is called the Brunner Test. It consists of 3 prongs that a debtor must prove by a preponderance of the evidence, which is just a basic convincing standard, whoever is more convincing. The first prong, 1, that debtor cannot maintain, based on current income and expenses, a minimal standard of living for himself if forced to repay the loans. 2, that additional circumstances exist indicating that this state of affairs is likely to persist for a significant portion of the repayment period for the student loans. And 3, that the debtor has made good faith efforts to repay the loans. Defendants argue that Wolfson fails to carry his burden on any of the 3 prongs. Remember, unlike most cases where the government is the plaintiff, in this case, the government is the defendant. So when they say defendants, they're talking about the Department of Education, first under Trump, now under Biden. But I, the bankruptcy judge, find otherwise. And remember, this is not an appeal. This is still at the lower court level. This is Judge Lori Silverstein, a United States bankruptcy judge. The evidence shows that, despite considerable effort, Wolfson has been chronically or underemployed since graduating from college, that his sporadic full-time employment has consisted of low-paying gig work or jobs with little prospect of advancement, and that he has avoided living in abject poverty only through significant financial support from his father. The record further shows that Wolfson's career prospects are unlikely to materially improve over time, and thus his inability to pay his student loan debt will persist. Wolfson has never made a payment on his student loans, but he has never been in a financial position to do so, and his continual search for gainful employment is enough to find good faith. Wolfson proved, by a preponderance of the evidence, that repayment of his student loans would result in an undue hardship, and accordingly, I conclude that the loans are dischargeable. In surveying the recent case law, I took note of the controversy generated by the Brunner Test, or rather the wide-ranging interpretations that courts have historically produced in applying that test. Courts of late have challenged interpretations that, through a combination of a legislative change and judicial gloss, result in a test that is far more onerous than the one first articulated in Brunner. This will be discussed in further detail below, but in short, I agree with the general premise that the most exacting interpretations of Brunner are unmoored from the original test and the plain language of undue burden. Wolfson filed a Chapter 7 petition July 20th, 2019. He was granted discharge October 22nd, 2019. The next day, Wolfson filed the instant adversarial action against Betsy DeVos in her capacity as the Secretary of the Department of Education and against the Pennsylvania Higher Education Assistive Agency, doing business as Fed Loan Servicing, Navient Solutions, and American Education Services, seeking a determination that his student loans are dischargeable. November 26th, Navient and Wolfson filed a stipulation of dismissal in which they agreed to discharge the Navient portion of Wolfson's student loan debt. That was approved. December 5th, Educational Credit Management Corporation moved to intervene as a defendant, explaining that it now owns the interests in Wolfson's student loans formerly held by the PHEAA. That motion was granted. The parties engaged in discovery. A trial was held December 7th, 2020. Wolfson was the only witness at trial. With an evidentiary record in hand, the matter is now ripe for decision. Wolfson was born in 1986. He was 34 years old at the time of trial. He is not married, does not have children. Wolfson has treatable, non-debilitating epilepsy. He was diagnosed with epilepsy with petit-mal seizures at age 12. His seizures were controlled with medication until about age 22. Since age 23, Wolfson has not taken medication for his seizures. His neurologist explained that he would have major liver disease if he continued the medication. Instead, he has been treating himself with cannabis, for which he obtained a medical cannabis card pursuant to Delaware state law. At one point, Wolfson suffered grand mal seizures due to excessive drinking. He has largely abstained from drinking for the last 10 years. Any current seizures are of the grand mal variety. He generally visits his doctor twice a year. His last doctor visit for his epilepsy was 8 or 9 months before trial. Wolfson graduated from Penn State in 2010, earning a Bachelor of Science in Business with concentrations in Management and Marketing. During college, he had various part-time jobs at his apartment complex, including as night security or taking tags at the pool in the summer. Immediately after graduating, Wolfson managed a hip-hop artist and co-owned a TV show with David Ivory called David Ivory Presents. Wolfson was also in charge of marketing for the show. Neither venture turned a profit and both failed by 2014. Since then, Wolfson has persistently sought work, but with little success. For example, from his graduation in 2010 through 2016, he had approximately 30 job interviews that yielded no job offers. During those years, 80% of the jobs he applied for were within his degree and experience. His efforts involved job boards, career fairs, and multiple recruiters. And the reason why I'm reading through this is you want to see what did he do to meet this undue burden standard for bankruptcy discharge, because this is instructive. If you are in a similar situation, you may find yourself within these factors and may be able to get your student loans discharged in bankruptcy. This is not individualized legal advice, and you will want to speak to a bankruptcy attorney in your area, because this is only going to apply to the Third Circuit for now. It's not even going to be precedential in the appellate sense. It's going to be persuasive in the your lawyer can cite to this case and say, look, this is how this court applied the undue burden standard. Starting in 2014, Wolfson cared for his grandmother full-time for approximately 2 years. For roughly 6 months after he stopped taking care of his grandmother full-time, he trimmed and packaged cannabis at a dispensary for minimum wage. Wolfson left this job voluntarily due to the low wages and issues with management. Starting in 2017, Wolfson worked for a home renovation company for about a year, developing leads for the company's door-to-door salesmen. In the last few months of his employment with the home renovation company, Wolfson began working part-time as a driver for rideshare and food delivery services. In 2018, Wolfson quit the home renovation company in order to work as a driver full-time. He worked as a full-time driver until he totaled his car in August 2019 after he suffered a seizure while driving. This was the first time that Wolfson suffered a seizure outside of the 6:30 to 9:30 a.m. time frame. Since totaling his car, he has been unemployed. Wolfson applied to approximately 200 jobs in the 10 months after he totaled his car, with no success. As with the job searches for the last 5 years, he is applying to any job he can find. But while Wolfson's epilepsy is not debilitating, it does limit his job search. He cannot take a job that starts before 9:30 a.m. due to the risk of seizure, and he cannot take a job which requires drug testing because of his cannabis use. Further, he cannot take a job that requires him to work after 8 p.m. because he begins to use cannabis at that time, and he must also maintain consistent quality sleep because of his epilepsy. Wolfson spends about 1 to 2 hours each day applying for jobs. He has not applied for unemployment insurance, nor for any disability. Also, back in 2019, Wolfson was forced to move back in with his parents, first his mother, then his father. His lease for an apartment in Wilmington expired in August 2019. He was prohibited from driving for 6 months because of the seizure, and he had no income. As of the time of trial, Wolfson was not working and had no income. Wolfson has relied on financial support from his father for his entire adult life, even when he was working. For example, as of the petition date, Wolfson's monthly income from his driver work was $1,137.39, and he received assistance from his father of about $1,335 per month for a total monthly income of about $2,472 per month. Matched against his then expenses of $2,475, Wolfson was essentially breaking even, but only with his father's help. His main expenses were rent of $725, which was mostly paid for by his father, electricity, food, car insurance, and transportation. As of the trial, Wolfson's expenses totaled approximately $1,430 per month, consisting of various bills: telephone, cell phone, internet, satellite cable services, food and housekeeping supplies, clothing, laundry, dry cleaning, personal care products, medical and dental expenses, transportation, and entertainment and recreation. $10 for entertainment and recreation. $60 to $75 for vehicle insurance, which Wolfson maintains for the purpose of borrowing other people's cars. Wolfson's father has paid all of Wolfson's expenses from the petition date to the trial. As of the date of the trial, Wolfson's father was still giving him about $1,000 per month. Prior to leaving Wilmington, Wolfson's father was contributing about $2,000 a month towards his living expenses. So his father has been very helpful and generous. Can you imagine if your parents do not have the ability or simply won't support you? How could you even make this bankruptcy petition like this? So if you find yourself in a position where you don't have the level of support that Wolfson had, you'll want to talk to your state's bar associations or even the state bar and ask for a referral to a legal clinic that can help you evaluate your bankruptcy candidacy and help you file for free or low cost if you cannot afford it. There is such a thing as an informa pauperis bankruptcy, where you can file bankruptcy without being able to pay for it. Wolfson has not had health insurance since he came off of his father's policy at age 25, followed by 2 years of insurance through the Affordable Care Act. He can't afford health insurance, and it would not cover his cannabis in any event. Wolfson's family gifted him the car he used to go to work and ultimately to work full-time as a Uber Lyft Grubhub driver. When the car was totaled, he received $6,000 in insurance proceeds. He used the funds to hold him over and pay some of his bills until he could find a new job. So he had to use the proceeds that would normally buy him another car to hold himself over, pay his bills, and find a new job. Wolfson's father is retired, around 74 years old, and lives in a one-bedroom apartment in Abington, Pennsylvania. He has suffered financial distress and impacted credit due to supporting his son. Like, if this isn't the perfect case for discharging the student loans, I don't know what is. So he has $95,000 in student loans, excluding late fees, interest, and other charges, 2 promissory notes, graduated in 2010, and his loans were supposed to be paid off by 2020. So the major part for people trying to understand what's going on here, his loans are all government loans. They have not been consolidated into private loans, which might still not be dischargeable in bankruptcy, but it's much different. Various payment plans and things apply to public government loans. So take that into consideration. Make sure you know all of your options if you choose to refinance your student loans into private loans. The Bankruptcy Code generally excludes certain educational loans from the Chapter 7 discharge. A discharge under the law does not discharge an individual debtor from any debt unless such debt would impose an undue hardship on the debtor and the debtor's dependents, for an educational benefit, overpayment, or loan made or guaranteed by a governmental unit, or made under any program funded in whole or part by government unit or nonprofit, or an obligation to repay funds received as an educational benefit, scholarship, or stipend, or any other educational loan that is a qualified educational loan as defined by the Internal Revenue Service, Internal Revenue Code. The parties agree that Wolfson's student loans are non-dischargeable unless he can prove the undue hardship standard. The Brunner Test we've gone over before. Minimal standard of living that is likely to persist for the significant portion of the student loan repayment period, and that the debtor has made a good faith effort to repay the loans. So we can start to skim a little bit here. A minimal standard of living is having one's basic needs met: food, shelter, utilities, transportation, healthcare, and some small source of recreation. The debtor does not need to live in abject poverty to fall below a minimal standard of living. The court must determine if the debtor, after maximizing income and minimizing expenses, will have disposable income with which to pay his student loan debt. The court does not count third-party charity, so the fact that he's been receiving assistance from his father does not affect the test. He has been substantially supported by his parents during this period. The support is not income, it is familial charity. The father is not legally obligated to provide it, so this cannot be considered for the undue burden test. This will make it more likely that he will meet the undue burden test. Even without having to repay his loans, Wolfson's income is insufficient to maintain a minimal standard of living. This is clearly the case at present, given that he is unemployed, has no income, and he has satisfied the court that he has made efforts to maximize his income. He has documented his long-running, expansive, and largely futile job search since graduation. Defendants, the Department of Education, make several arguments. They contend that spending only 1 hour a day seeking employment is barely looking for work. This might have been a fair characterization in the past, but today, online job applications are ubiquitous and often the only way to apply for a job. Wolfson's lack of success does not appear to stem from the amount of time he spends on job applications. At least the DOE elicited no evidence to that effect. Nor is Wolfson avoiding work. ECMC argued that Wolfson was holding out for a job that would allow him to move out on his own, but this misstates Wolfson's testimony. Wolfson did testify that he was applying to anything that pays well enough to live on my own, but he did not say that he was ignoring jobs below a certain level of pay. On the contrary, when asked what sort of jobs he's been looking for, he replied, anything, and that's been my way for over about 5 years now. His employment history supports his testimony. He estimates he's had over 30 jobs throughout his life. Wolfson's motley assortment of past jobs contradicts the suggestion that he has been picky, and there is no evidence whatsoever that he has turned down offers for work. While Wolfson's circumstances changed considerably since he originally filed his Chapter 7 petition, complicating this analysis somewhat, ultimately it remains clear that he meets prong 1. His expenses were and are still minimal, and defendants did not challenge any of Wolfson's spending. The only apparent controversial item in Wolfson's budget is the approximately $400 a month he spends on cannabis, which he takes for epilepsy in lieu of pharmaceuticals. But Wolfson obtained a medical cannabis card under Delaware law. In any event, removing this expense does little to improve his budget. He does not have health insurance, and it is undisputed that his epilepsy requires treatment. Any savings realized by eliminating his cannabis usage would likely be at least offset by health insurance and medication costs, which Wolfson currently does not pay. Thus, if anything, Wolfson's expenses appear to be understated because healthcare is a necessary component of a minimal standard of living. Based on Wolfson's current income and expenses, he cannot maintain a minimal standard of living if forced to repay the loans. Prong 1 of the Brunner Test is satisfied. Whether the inability to pay will persist. The repayment period should consist of the contract term currently in force, not a hypothetical term that might apply had the debtor entered a repayment plan. So how this works, most student loans are on a 10-year repayment plan, but you can extend that through being unable to pay it off, basically. If you don't pay it off within the 10 years, then technically the whole loan becomes due immediately. But if you're on a repayment plan, I believe you get 20 to 25 years to pay it off based on your income, some calculation thereof. There are 4 income-based repayment plans that you can choose from. They have different consequences and different burdens, requirements. So talk to your student loan advisor. They're supposed to give you advice in your best interest, I believe, in helping you figure out what to do. You also have some private resources, like Betty from the Student Loan Assistance something or other. I'll put a link up on the screen and in the description below. If you want to get help, you can apply to several student loan assistance organizations. Here, the 10-year repayment period has run for Wolfson. It is likely that both loans were accelerated upon default. Regardless, this leaves me with the thorny question of how, for the purposes of the Brunner Test, to treat a repayment period that has already run. There is a near complete lack of authority on this issue, and only 2 of the many cases reviewed confront it. In the Rosenberg case, Chief Judge Morris found that because the debtor's loans were accelerated and his repayment period ended, the debtor met the second prong as a matter of law. Chief Judge Morris did not elaborate on her reasoning, likely because it is obvious. The second prong calls on the court to predict the events of a set future period. If that period has already passed, there is nothing to predict, and the inquiry necessarily ends in the debtor's favor. In the bankruptcy of Nitcher, the court concluded that the applicable repayment period for prong 2 is the contractual repayment term for each loan, resulting in repayment periods of 0 for 2 of the 3 loans at issue. Judge McKittrick relied on what he correctly characterized as the in-depth analysis of a price case. The price court, while not faced with a contract term that had already expired, engaged in an extended discussion of the appropriate repayment period. Judge Frank there concluded that at least where a debtor chose in good faith not to enter into an extended term student loan repayment program, the repayment period is the remaining term on the contract. I join Chief Judge Morris and Judge McKittrick in applying the second prong of the Brunner Test as written and conclude that Wolfson satisfies this prong because his repayment period has already ended. The second prong also requires that the debtor prove that additional circumstances exist, indicating that he cannot maintain a minimal standard of living. There are no set requirements for what constitutes additional circumstances, but recurring examples include long-term physical or mental health problems, precluding employment, lack of marketable job skills, or the necessity of fully supporting several dependents, which precludes sufficient income. The list is not exhaustive, and the presence or absence of any particular circumstance is not dispositive. The inquiry is fact-intensive and case-specific, and so she's going to say that he meets the test. Wolfson is not just able, but is likely to be employed in the future. However, his work history shows that he is unlikely to ever receive an income sufficient to pay his student loan debt. He is still young and has a college degree, and if he were perhaps only a year or 2 removed from his graduation, I could be more sanguine about Wolfson's future. But a decade has passed, and in the wake of his failed postgraduate entrepreneurial ventures, Wolfson's resume consists of unprofitable gig work and low to minimum wage jobs bearing little hope of advancement. punctuated by periods of unemployment. I cannot find, as defendants argue, that we don't know what the future holds for the plaintiff or that 6 months later his circumstances may change. Simply put, Wolfson's is not the sort of background employers are looking for. There is no reason to think that a brighter future is in store. Wolfson's student loan debt now totals around $100,000 and is growing, and it is a virtual impossibility that he will ever pay it off, regardless of the length of a hypothetical repayment period. While it pains me to assign him such grim prospects, viewing Wolfson's situation with unwarranted optimism will only do him a disservice. The third prong of the Brunner Test, good faith effort to repay. The final prong requires a debtor to prove a good faith effort to repay his loans. The good faith inquiry is to be guided by the understanding that undue hardship encompasses a notion the debtor may not willfully or negligently cause his own default, but rather his condition must result from factors beyond his reasonable control. The debtor's history of payment on the loans is not itself dispositive, rather courts focus on the debtor's efforts to pay, and whether the debtor can justify a history of non-payment. To that end, courts examine the debtor's efforts to obtain employment, maximize income, and minimize expenses. Courts also consider the debtor's consideration of and participation in income-based repayment plans, but the significance of such repayment plans is necessarily dependent on the circumstances of the particular debtor seeking to discharge his or her loans. Though Wolfson has never made a voluntary payment on his student loans, he has never been in a financial position to do so and has shown good faith in his efforts to maximize income and minimize expenses as described in prong 1 of the analysis. Wolfson credibly testified as to his efforts to obtain gainful employment, and defendants provided no evidence to the contrary. It is plain that Wolfson's history of low-paying jobs and gig work comes from necessity, not choice, and at no point has Wolfson had steady surpluses of income that would allow him to pay down the loans. Though Wolfson has restricted his job search in conformity with his medical condition and drug testing requirements, his testimony as to those requirements went undisputed or uncontroverted. Defendants did not contest the necessity of the restrictions, and I'm persuaded that Wolfson observes these limitations in good faith. He is not using these limitations to dodge work, which is again corroborated by the variety of jobs he has worked in the past, and those restrictions are not so onerous as to explain Wolfson's marked lack of success in finding work in general. Defendants suggest that Wolfson may have been able to eke out at least some token payments as a demonstration of good faith, pointing in particular to the $6,000 in insurance coverage Wolfson received for his totaled car, which would normally be used to buy a replacement car. That is a terrible, terrible assertion from defendants and completely overlooks what that money was for. Wolfson testified that he used the money on living expenses, but defendants argued that he could have carved off some portion of it to pay down his student loans. While this would be helpful to Wolfson's case, I will not fault debtors for failing to make payments that are ultimately performative when their overall financial position makes those payments futile. It is enough to show, as Wolfson has, that the debtor has made a good faith effort to maximize income and minimize expenses, and that the failure to make payments stems from inability, not unwillingness. Wolfson's choice not to enter an income-based repayment plan does not preclude a finding of good faith, because his future employment prospects make it unlikely that he will ever make meaningful payments on such a plan. In other words, he's making so little income that he wouldn't be required to make any payments at all. His payments would be zero under the repayment plan. So how does that make a difference? It's a difference in name, but it's a difference in name only. Wolfson testified that he briefly explored these plans and rejected them, reasoning that they were pointless for someone in his circumstances. I agree, says the judge. This is not a case where the debtor's earnings are likely to substantially increase over time, a recently graduated medical doctor, for example. Nor is this a case where the debtor's financial hardship is temporary, a passing illness, or a brief window of unemployment in an otherwise steady career. Defendants argue that we don't know what the future holds for Wolfson, implying that he may happen across some lucrative career path that has evaded him these past 10 years and will allow him to pay his debt. Yes, he's just a temporarily embarrassed millionaire, right? So he doesn't have $1 million but he's going to have it. He's just temporarily embarrassed by his lack of millions of dollars right now, right? But this is mere speculation unsupported by the record. The record indicates that low income will be a persistent feature of Wolfson's life, and that all an income-based repayment plan will accomplish in his circumstances is to waylay the discharge of his debts for an additional 10 to 25 years, while continuing to sabotage any chance of improving his credit. His failure to engage in this futile exercise does not amount to bad faith. Despite his apparent best efforts to maximize income and minimize expenses, Wolfson has never had the discretionary income to make meaningful payments on his loans. Because the record indicates that this state of affairs will continue, he cannot be faulted for declining to enter an income-based repayment plan. Wolfson has carried the burden on the third Brunner prong. Given the ultimate outcome will be substantially the same, there is little benefit to the system in delaying the discharge of Wolfson's loans. Conversely, the fresh start interest in this case is fairly strong. Wolfson is 34 years old and remains dependent on his aging retired father. He faces an uphill battle in improving his situation, and his father's support cannot continue forever. The burden of student loans only adds to the precarity of his circumstances. The competing policy concerns here weigh in favor of granting the discharge. For the foregoing reasons, I conclude that Wolfson has proven by a preponderance of the evidence that accepting his student loan debt from discharge would impose an undue hardship on him. Since graduating from college, this debtor could not afford a modest apartment, food to eat, or basic transportation without his father's assistance. It is not for want of a work ethic. His assortment of jobs, even while working full-time, did not permit repayment of his student loans, and there is no evidence to suggest that his plight will improve, and Wolfson is therefore entitled to a discharge. So boom, that's how you get rid of your student loans in bankruptcy. This is not a good circumstance. If you find yourself in a circumstance that would meet the Brunner Test or even require bankruptcy, you're in bad financial condition. And one of the policies behind bankruptcy is to not sentence someone to a life of indentured servitude or a life of constant battling debt collectors and creditors for your debts. If you aren't familiar with what we call the poor tax, it's not a real tax in the sense that the IRS taxes you for being poor, but there is an effective tax or burden to being poor. You can't afford good, healthy food, so you eat terrible food, and you have more health conditions that require you to pay for healthcare treatment. You can't afford good shoes or durable clothing or comfortable clothing, so you live in discomfort and your clothing wears out faster, ultimately costing more than if you bought good clothing or good shoes. You might buy the cheap appliances and the cheap kitchenware and cheap items for your living, and they may wear out quicker, and you may not be able to get them fixed because you can't afford to. So we say, if you buy cheap, you buy twice. So it's sometimes better to buy an expensive, durable item that will last longer. But poor people generally can't afford to buy good items. They buy the best that they can afford, or they buy the cheapest. So these things result in a constant churning of the debtor, the poor person who can't get out of debt or get out of poverty. They may make the mistake of getting an advancement on their paycheck at a high interest rate, and then something happens that prevents them from making up the difference, and then they have to get an advancement on the next paycheck, hence the churning of the paycheck loan situation that you've heard others talk about before. They may overdraw their bank account and have excessive overdraft fees imposed on them, and that puts them even further into debt. And the bank may eventually close their account, and they may not be able to get a bank account. And because they can't get a bank account, now they have to get their paychecks cashed at a paycheck cashing place, which charges excessive fees. It is terrible what our society does to poor people. And all of this while the government generally, depending upon where you live, generally makes it more difficult for poor people to obtain assistance than necessary. So it's a difficult situation. It's an impossible situation in many places for people who are in poverty. And here, this person took the ubiquitous advice from the 80s and 90s, which was to always go to college no matter what the cost. And it turns out that when everybody goes to college and the government gives you unlimited loans at a high interest rate, that people will go to college, not be able to improve their circumstances enough to overcome the burden of the debts incurred. So it's a terrible situation that really needs some fixing. But then you have the Biden administration, who now wants to appeal this decision discharging Mr. Wolfson's student loan debts. Let's take a look at that real quick. On January 28th, 2022, just a few days ago, about a week ago, the U.S. Attorney's Office filed a notice of appeal on behalf of the Department of Education, appealing the decision in Mr. Wolfson's case. Appeal of the bankruptcy court's judgment on the complaint to determine dischargeability of student loans, finding that debtor Ryan K., it says Wilson, but it's Wolfson. Student loan debt was dischargeable under the law. Also, it appears that Mr. Wolfson is represented by attorney Timothy Wheeler or Weiler. Thank you very much. Shout out to Mr. Weiler for doing all this work for Mr. Wolfson. Really, really good job getting him this discharge. I think it's terrible that both the Trump administration and now the Biden administration are opposed to the discharge of student loan debt for bankruptcy filers who have met the undue burden test according to their district courts or their bankruptcy courts. If you recall, there was a case where Betsy DeVos and the Trump administration opposed the discharge of a debtor who met this case. I think it was in New York. And now we have the Biden administration appealing Mr. Wolfson's Delaware bankruptcy discharge of his student loans. What are these people supposed to do? Just be in debt their entire life? I don't get it. I don't get it why you would have a bankruptcy system to prevent exactly this from happening, and then you would make an exception preventing people from getting the relief that they need. People who are sincere and genuine bankruptcy filers who would never be able to pay back their student loans. But I do have good news. There was a lot of pressure when this notice of appeal was filed, and I can now say with confidence that the Biden administration is dropping its appeal of the legal victory for the student loan borrower with epilepsy in bankruptcy court. Why they would have opposed in the first place, I don't know, but I'm glad that they're dropping the appeal. And I am a little bit ashamed, sad that President Biden and his administration campaigned on a promise to cancel student loan debt, even partially, and have now resisted canceling any student loan debt at all. They have extended the student loan payment moratorium till May 1st. Reminder, if you have student loans, they're going to restart again May 1st. Get ready. But they haven't extended it further. They haven't zeroed or lowered the interest rates for student loans. And they certainly haven't canceled any part of student loans for the majority of borrowers. I believe there was some kind of cancellation based on misconduct conducted by Navient. If I recall the case correctly, Navient is or was accused of giving people bad advice. I've had this happen in my case as well. Navient or whoever my student loan repayment servicer was back in the day told me to put my loans into forbearance when I had no income instead of putting them into an income-based repayment plan. And so I've gotten a late start on my income-based repayment plan. And if I don't get my forgiveness based on my income-based repayment plan when I think I'm due for it, I'm going to have to sue the Department of Education and argue that that advice was incorrect and they should have told me to put it myself onto an income-based repayment plan. So in other words, I'm like 3 years behind my income-based repayment plan forgivability or discharge. So yeah, let me know what you think of that. That was a remarkable case, and I'm looking forward to some kind of relief when our politicians someday figure out that oppressive student loans don't help people make more money. I'm even kind of surprised that we have such high costs for education alone. If you look at the economics of it, encouraging people to go to college and get an education is a good idea, but saddling them with excessive debt at high interest rates makes it difficult for them to then realize the gains that they went to school for. So they put in the effort for schooling. They might even get a good job and make a good amount of money, but then they can't realize the gains of that because they have to pay back those student loans at a high interest rate. Maybe what we do is we adopt a policy where the college is low cost or free for most people or all people. The living expenses while you're going to school can be paid by loans that you have to pay back, but the interest rate is capped at a low interest rate, like 0 or 1% or something tied to the federal funds rate or something, not a fixed 5.25% or 5.5%, which is what my graduate loans are at right now. It makes it impossible to pay once your student loans get over a certain amount. And because I couldn't pay my student loans back right away, because I didn't get a job right away, because I didn't have high income right away. Remember, law school ends usually in May. Your student loans begin in June, but you don't take the bar exam till July, and you don't get your results till October. And then you might have a job lined up. So you have the first 6 months of interest are accumulating, and my loans were accumulating interest at over $1,000 a month. So I got $6,000, $7,000 added to my student loans just from not being able to work while I'm studying for the bar exam and passing my bar exam. It's very unfair. However, I'm not going to ask for sympathy for lawyers because we aren't really that sympathetic of a group. But generally speaking, people are suffering. Some people are fine, and many people have worked very hard to pay off their student loans, and I am not minimizing that at all. I'm talking about the people who have also worked very hard but have been unable to pay off their student loans. They deserve some kind of relief. Let me know what you think. This is a controversial issue. Like I just said, some people worked very hard. Some people didn't go to school because they didn't want the loans. Some people have suffered because they didn't want to be in this situation. And if we grant student loan relief, or if we change the system, some people will feel like they missed an opportunity that they could have taken if they had only known that there would be relief later. It's a very complicated situation, and I think it's a terrible one for our governments to put our students in. Last thought, there is some economic support for the fact that people who earn more then pay more in taxes because of progressive income taxes and contribute more to society in the form of taxes and trickle-down economics, for lack of a better word. They are able to buy a bigger house. They pay more in property taxes. They are able to pay more for home improvements or buy a better car or something like that. So more money is put into the economy and the taxes for the government to spend on everyone because people got better jobs. If we take that money away because of student loans and we cap the amount of interest that they can write off on their student loans, we're just saddling them with high interest rate debt and lowering the amount that they can participate in society. And I think that's cutting your nose to spite your face. That's hurting yourself because you made a bad policy. And I think that needs to be corrected. Let me know what you think in the comments below. Thanks for watching. Special thanks to my top supporters in February: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Gutbrodj, Torpedan, ShadowTycho, Earthbound Star, PureMagma, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everybody has a great week. I love you all.